Imagine this. You buy your dream home, you're excited to settle in, and then, bam, just a few months later, you find yourself in a legal battle with your own neighbors. Well, that is exactly what happened in the case we're looking at today. We're going to unpack the official court documents to see how a seemingly simple request for records blew up into a full-blown formal dispute. If you've ever lived in a neighborhood with an HOA, chances are you've had a disagreement or two, right? Usually it's something small like, hey, your grass is too long, or where you can park your car. But what happens when the stakes get way, way higher? Well, this explainer dives deep into a case where one homeowner's concerns took him straight to a courtroom. So here's our game plan. First, we'll get to know the people involved. Then, we're going to hear both sides of the story, the homeowner's pretty serious claims and the association's defense. After that, we'll dig into the exact law the judge had to use to make a decision, and then, of course, the final verdict. And stick around for the most important part, what this whole thing actually means for you. All right, let's set the scene. Our story centers on a homeowner named Michael Palacios. In this legal case, he's called the petitioner. That's just the person bringing the complaint. And he's going up against his HOA, the Rio Community Association in Arizona. Now, here's the kicker. Mr. Palacios wasn't just some random resident. He had just been appointed to the HOA's board of directors. And things escalated fast. I mean, look at this timeline. Mr. Palacios buys his home in early March. By the end of that same month, he's on the board and has already put in a formal request to see the association's financial records. Just over a month later, he's filed a legal petition against them. So we go from new homeowner to legal opponent in just 5 months. That's an incredibly quick escalation. So what was the big deal? Why would a brand new board member feel like he had to take his own association to court? Let's break down exactly what Mr. Palacios was claiming. Okay, the whole thing started with that records request. As a director, Mr. Palacios had every right to inspect all the association's books. So he asked, but he claimed what he got back was basically nothing. He testified that he received only about 5% of what he actually asked for. Now that is a huge red flag for anyone. And he wasn't just being vague about it either. He was very specific. He pointed to things that should have been there but weren't, like contracts with the management company, with lawyers, with landscapers. But it got even more serious. He claimed that some of the paperwork he did get looked suspicious because it used the wrong name for the association. To him, this wasn't just sloppy bookkeeping. He was worried about potential fraud that could hurt his property value. All right, but as we all know, there are two sides to every story. So now let's hear from the association. They were represented by their manager, Denise Ferreira, and she painted a very, very different picture. The HOA manager basically had an answer for every single one of his claims. Those missing contracts, she testified they just didn't exist. They paid those vendors on an as-needed basis, and all the payments were right there in the financial ledgers he received. The delay on the bank records, well, she said that was the bank's fault. It just took them time to process a big request. And that supposedly fraudulent name, she explained it was just a messy, unofficial rebranding attempt by some other board members that she had already told them to stop using. So from the HOA's point of view, this was all just a big misunderstanding, not some grand conspiracy. So what do you do with that? You have two completely opposite stories. You've got a homeowner who's convinced something shady is going on, and an HOA manager who's saying everything is perfectly fine. When it's just one person's word against another's, how does a judge possibly decide who's telling the truth? Well, it all comes down to the law. This right here is the legal bedrock of the whole case. The law in Arizona is crystal clear. When a member asks to see the records, the association has 10 business days to make them available. The entire dispute really boils down to one question. Did the association break this specific rule? Now, in any legal fight, there's this really crucial concept called the burden of proof. It basically answers the question, who has to prove their case? In this situation, the burden was 100% on Mr. Palacios. It wasn't the HOA's job to prove they were innocent. It was his job to prove they were guilty of breaking that 10-day law. So what does proving it really mean? It's not like a criminal case where you need proof beyond a reasonable doubt. The standard here is much lower. It's called a preponderance of the evidence. The best way to think about it is like tipping the scales of justice. Mr. Palacios had to provide enough solid evidence to make the judge think, okay, it's more likely than not that the HOA failed to hand over records that actually existed.
So the law is clear. Both sides have told their stories, and now the administrative law judge has to make the final call. Did Mr. Palacios manage to tip those scales of justice in his favor?
The answer from the judge was a very clear no. The final ruling says it all. Mr. Palacios did not meet his burden of proof. He lost the case. But the reasoning behind that decision is where the real lesson is.
So why did he lose?
Well, the judge found that the HOA did respond on time and that they kept him in the loop about any delays, like waiting on the bank. But here's the knockout punch. The judge said Mr. Palacios presented no credible evidence that documents existed which were not disclosed. See, he suspected there were missing contracts, but the HOA testified they didn't exist, and he had no way to prove they did. The judge basically said that suspicion isn't proof, and that really shows you how tough meeting that burden of proof can be.
Okay, let's zoom out from this one specific case for a minute, because there are some really powerful takeaways here for anyone who lives in or is thinking about living in a homeowners association. First off, there's a real financial risk. Filing this petition cost Mr. Palacios $500. And because the judge ruled against him, he doesn't get that money back from the HOA. So not only did he lose his case, he's also out $500.
And this brings us to the single most important lesson of this entire explainer. Mr. Palacios may have genuinely, truly believed that something was wrong. But in a court of law, your beliefs and your suspicions, they just aren't enough. This case wasn't decided on who was more sincere. It was decided on who had the credible evidence.
And that leaves us with one last big question to think about. The burden of proof is a cornerstone of our legal system, and it's there for a good reason, to stop people from making accusations without evidence. But think about it. When it's just one homeowner going up against an entire association that has more money and more resources, is that standard truly fair? Or does it sometimes become an impossible hurdle for the little guy? It's definitely something to chew on.